I want to welcome you all to our noon panel on the legacy of Justice Ruth Bader Ginsburg. I figure if I keep talking, then we'll have... Great to be with you all this afternoon and see some very familiar faces. The purpose of this panel, as I said, is to explore the legacy of Justice Ruth Bader Ginsburg. I think we'd have to agree that there's been no single person probably on the planet who has done more to promote sex equality than Ruth Bader Ginsburg. She's been an impact player, I think along the lines, I don't know if my panelists would agree with me, of Susan B. Anthony and Elizabeth Cady Stanton and so on, in terms of her impact on the law and how we think about sex discrimination. During this panel, we're going to explore Ginsburg the person, Ginsburg the advocate, and Ginsburg the judge and justice through the lens of a fascinating book published this year by Cambridge University Press and edited by Scott Dodson, who's to my left, a 2000 graduate of this law school back, I assume, for his 15th reunion. So we're glad to have him here. Scott is a professor at UC Hastings School of Law and has also taught at William & Mary, the University of Arkansas, and he visited here in 2008. Scott specializes in civil procedure in federal courts and has written more than 35 articles in top law reviews as well as books in the civil procedure area. He comments frequently in the news media and on various Supreme Court and federal courts blogs, and as I say, we're really happy to have him here. Scott is joined by the authors of two of the chapters in this volume, Lisa Griffin to his left. Lisa is a graduate of Stanford Law School, where she was president of the Stanford Law Review. She clerked on the Ninth Circuit Court of Appeals for Dorothy Nelson, and then on the Supreme Court for Justice Sandra Day O'Connor, after which she served for 5 years as a federal prosecutor in the U.S. Attorney's Office in Chicago, and then taught at UCLA. Lisa specializes in evidence, constitutional criminal procedure, and federal criminal justice policy, and she's been on this faculty since 2008. Finally, Neil Siegel is the David W. Ichel Professor of Law here, as well as co-director of the program in public law and the director of our D.C. Summer Institute on Law and Policy. Neil obtained his undergraduate degree from Duke University and his law degree and a PhD in jurisprudence and social policy from UC Berkeley. After that, Neil was a Bristow Fellow in the Solicitor General's Office of the Department of Justice. He clerked for Judge Harvey Wilkinson on the Fourth Circuit Court of Appeals, and in 2003-2004, he clerked for Justice Ginsburg on the Supreme Court. Neil is one of our core faculty in the constitutional law area with special interests in, among other things, the Affordable Care Act and discrimination based on race, sex, and sexual orientation. So we're going to start just with kind of a 1 minute or two introduction of the book, and I want to ask Scott to tell you a little bit about what brought this project about. Scott, why did you decide to do it? How did you go about it? And what were you hoping to accomplish?
Well, thanks, and thanks very much to Neil and Lisa and Kate for joining me on this panel. It's really a delight to be here. I think I came to this project in kind of an unorthodox way for this kind of a book. I don't have a connection to Justice Ginsburg, at least not a personal or a professional one. I teach civil procedure, and not only that, but I write in civil procedure, and I love civil procedure. I'm kind of a rare breed, and it's hard to find people like that. But as I was teaching it, I came across Justice Ginsburg's casebook-worthy, deep, scholarly opinions in civil procedure, and I felt a kindred spirit from afar. And of course, I knew of her gender equality decisions and legacy in that area, but I thought, here's a justice who has had 50 years influencing the law in a variety of different capacities. There's a story there, and it needs to be told. And so I put in a call. My first call was actually to Neil. And I said, is this a good idea? do you think Justice Ginsburg would be offended? And I think he showed some support for the idea. I then called a few other people that I trusted and got the same kind of reaction, and then put together a list of all-star contributors to really speak to how Justice Ginsburg has influenced the law in various subject matter areas. The list pretty much came together very easily. It seemed like everyone wanted to write about her. And finally, the book came out. What I really hoped to do with this was just chronicle and document this remarkable legacy that she has had after these 50 years in the law. I mean, she's been a law professor, she's been an advocate, she's been a court of appeals judge, and she's been a justice. And in each of those areas, she really has made a big difference, both in the law and society, and I hope that's the book that tells that story.
Right. Lisa or Neil, do you want to add anything about your participation in the book? I know Neil doesn't turn down any occasion to talk about his former boss, but...
Well, I'd like to talk a little bit about Scott and celebrate Scott. He's our graduate. He's a prominent academic. When he approached me, I was supportive of the idea, and Scott is not alone. I mean, we are a law school that produces prominent academics, and we're intent on doing it again. And so for me, it was about, there really isn't a book like this one out there, and I think it's too early just to be looking back, because I think some of Justice Ginsburg's most important opinions have yet to be written, and in fact are maybe being written as we speak. But nonetheless, 50 years is a long time, and I think it's appropriate to look at the legacy across a lot of areas, obvious and not so obvious, and in doing so, not just to chronicle and document her, but also celebrate our graduate Scott for his great achievement in putting this together.
Can I say something about Scott and Neil? So I got involved with the book because I had the good fortune to get to know Scott a little bit when he visited at Duke, and I count myself very lucky that that happened. Even in our brief time as colleagues, I learned very quickly what a force of nature he is when it comes to producing scholarship and the energy and enthusiasm that he has for these projects. And that memory won me over, despite, I think, being a somewhat unlikely candidate and having a somewhat unlikely topic, given that the legacy with regard to criminal procedure is a little bit harder to discern. And I also did it because Neil is across the hall from me and has the office there, and that cuts both ways. So it took a little courage to write anything about Justice Ginsburg with Neil's expertise and affection so apparent from across the hall, but I also knew that he would be the best and most careful reader of anything that I did write, and I was able to count on him to help me with it. So I owe a debt of gratitude to both of them, and it's because of the two of them that I'm in the book at all.
So I want to spend a moment on Justice Ginsburg's early influences, and I want to start with an interview some of you may have seen that Walter Dellinger did here in 2005, which talks about her mother. She lost her mother on the day she graduated from high school?
It was the day before her high school.
The day before her high school graduation, but this is a very short clip when she's talking about her mother.
What did you learn from your mother?
I learned to love to read and to be independent. My mother told me two things constantly. One was to be a lady, and the other was to be independent. Now, the latter was something most unusual for those times, because for most girls growing up in the 40s, the most important degree was not your BA, but your MRS. You were to find Prince Charming and live happily ever after. My mother certainly thought it would be fine if I married, but she said it was most important for me to be able to carry my own load, to get a job and support myself. And be a lady meant Don't react to life situations in anger. Don't consume any of your time on such emotions as envy, because they just sap energy and have no productive value. So it was to react calmly and not let things hurt you. Those were the main things.
She must have been really proud of what a wonderful student you were in high school and college.
Well, sadly, she died when I was 17, so she died the day before my high school graduation.
Well, it's she missed.
So what else might we want to say about her? It's obviously a very personal statement about her mother. What else do we know about her early life that tells us, that sheds some light upon who she became? Anyone?
Well, I'll start. I guess, I think she speaks the truth. We should listen to her. She seemed incredibly driven and unafraid to be successful during those early years. She was valedictorian at Cornell, where she studied in the bathroom to avoid being seen as unfun. But she did it because she thought that was important, and she wasn't there just for an MRS. She was one of a very few women to matriculate at Harvard Law School at the time, a huge credit to her scholarly acumen. She was elected to the Harvard Law Review. She was only one of 9 women to matriculate that year out of a class of like 550. She continued to excel after law school despite not being able to get a job initially. She had to be, one of her professors had to coerce a judge into hiring her for a clerkship. And then she got a job at Rutgers and excelled there as well. She wrote the first casebook on sex discrimination. She was a passionate advocate for the ACLU. She co-founded the Women's Rights Project. So she had independence and drive to succeed in those early years.
We all set on that? Okay. So let's talk a little bit about her career as an advocate. As Scott said, she helped to form the ACLU's Women's Rights Project. And just to say a bit about her strategy as an advocate, I would say, and one of the things that Joan Williams, who writes a chapter in this book, emphasizes, is that her litigation strategy concentrated on challenging the dyad between male as breadwinner and female as homemaker. In that context, some of the sex-based classifications she challenged were classifications that hurt women, but she's well known for having also brought a number of suits, I think maybe even more, greater number of suits with male plaintiffs, suits that challenge stereotypes that work against men. And I think she had 2 reasons for this, maybe 3. One was that she saw that the same stereotypes that the stereotypes that applied to men also hurt women, that they didn't just hurt men, but that they hurt women as well. And secondly, I think she was concerned about sex equality for men as well as for women. It may have also been partly a strategy to educate the world, to educate judges, other lawyers, that this was a problem that was that went across gender lines, that it was an important thing to fix in society, that we stereotyped men and women in various ways, in ways that kept them from being to being the best they could be. So it made perfect sense that she would target discriminations against both men and women. The first case she was involved in that was a Supreme Court case was Reed versus Reed, which is this case out of Idaho, which was the first case in which the Supreme Court found that sex discrimination could be a problem under the Equal Protection clause. It wasn't clear exactly what standard they applied, but it was more than the standard that had been used routinely up until then to uphold sex-based classifications. It was a rather minor matter of a appointment of an estate administrator. The deceased actually took his own life, and the father stepped in to administer the estate because the child's mother was, he said, she worked on the brief that successfully challenged that case. And as I say, that was the first case among a string of others that Justice Ginsburg was involved in setting the new standard for review of sex-based classifications. What else do we want to talk about in terms of her life as an advocate?
I just want to flesh out a little more an important point that Kate just made about her advocacy. The advocacy was not about opposition to any and all gender articulation. The idea of first be a lady, I think, speaks to that, among other things. It wasn't even about any kind of gender differentiation that government might engage in. It was rather certain kinds of gender lines that would reflect or reinforce the inferior social status, the exclusion of women from core areas of citizenship, from educational life, from economic life, from political life. What she went after was instances in which government was reinforcing the separate spheres tradition, the tradition that Justice Bradley and Bradwell against Illinois spoke to when he talked about the destiny of woman being to be in the home and raise a family. This is the law of the Creator. And a century later, then Professor Ginsburg would write in a brief to the court that the method of communication between the jurist and the Creator is never disclosed. But this kind of talk has long been used to reinforce the inferior social status, right, the unequal citizenship stature of women. And I think that explains why she went after what she did and why she didn't go after what she didn't go after. She was not concerned about sex-segregated bathrooms, which became an issue in opposition to the ERA. She called it the potty issue, dismissively. She was concerned about things like pregnancy discrimination. Like once a woman becomes pregnant, her job is terminated. Right, she no longer has employment. The ability of women to participate equally in the economic, political, social life of the nation, and that meant not just that women would occupy untraditional roles, but that men would as well. Someone has to raise the children. Someone has to clean the kitchen. And if it's not going to always only be women, well, then the men have to step up too. And she learned that in Sweden. She went there. She taught herself Swedish and wrote a book on Swedish civil procedure. And Scott is right. I mean, I like procedure as much as the next person. I teach federal courts, but not like them. And she is a procedure nut. I mean, she got totally hooked on some of the most technical procedure cases my term when there were, in my view, bigger fish to fry, but not in hers. She went there and then she witnessed this sexual revolution taking place in Sweden. It was almost by accident that she became so invested in this fight for sex equality, and she saw not just women occupying untraditional roles, but men as well. And I think that, much more than strategic considerations, was why she represented male plaintiffs. Cases that were near and dear to her heart were cases in which men wanted to function, to exist as present fathers, particularly when the mother was absent or passed away. And the men were being denied benefits that, if it had been the mother, they would have received. And those are the cases near and dear to her heart. And strategically, it didn't always make the most sense to have male plaintiffs. Because if you're dealing with, at the time, very conventional male judges, there were cases in which they were much more offended by the idea of men being caregivers than they were by women being breadwinners. There were cases in which some of the judges don't understand. Is the man simply lazy? He doesn't want to work, as if raising children is, the easiest thing in the world. So I think it's because she wanted to disestablish traditional gender norms and free both sexes of them that she represented male plaintiffs, and I think was misunderstood by her critics as being an advocate of mere formal equality. I don't think that was it at all.
I'll just add that I think she lived that experience too. She married Marty Ginsburg when she was 17, and they had their first daughter, or they had their daughter Jane when they were both at Harvard Law School. And Marty reports that Ruth Ginsburg was a fairly terrible cook, and for lack of interest, unlikely to improve. And so Marty took the primary role of cooking for the family and became quite an accomplished chef in his own right. And so I think the separate spheres were dismantled even within Ginsburg's own family circle.
So in one of the final chapters of the book, Dahlia Lithwick mentions that on her 12 years on the D.C. Court of Appeals, she voted more often with her Republican colleagues than with her fellow Democrats. And in particular, the statistic she gives is that she agreed 85% of the time with then Judge Robert Bork and only 38% of the time with Patricia Wald. I'm not sure that any of us are prepared to speak about that statistic or why, but I think it is important to see. I myself see her as being, at least in that judgeship and in her early years on the Supreme Court, fairly cautious, kind of a peacemaker. She spoke in the clip of not wanting to rattle all the dishes in the cupboard. She moved kind of slowly, so slowly, in fact, that when I was a fellow at the National Humanities Center in 1992, I received a call from Marty Ginsburg. I knew him. I had met him, but I wouldn't say I knew him, and I was quite surprised to get this phone call. And the reason he was calling was that he knew that I knew Walter Dellinger. And he said, I really think that my wife Ruth needs to be on the Supreme Court, and it's well known how much he lobbied to get this to happen. And I'm getting the word that the women's groups don't think she's okay on the abortion issue. And so I want you to get in touch with your friend. It was like he was giving me a list, and I was, I want you to get in touch with your friend Walter Dellinger and assure him that that Ruth is okay on the abortion issue. And the genesis of that, I believe, although someone on the panel may have something to add on this, was that she had said that she thought Roe versus Wade went too soon, too fast. That it was that the whole issue was in the process of developing politically in the legislatures, and that this really kind of stirred up the hornet's nest that may not have been necessary. Any thoughts on that, or?
I think she is an incrementalist. I think she would rather, and in that sense, she is a conservative. You could talk about values of caution, but she's acutely aware that the exercise of judicial power is not self-validating. The court doesn't get to decide the really big issues for all time. It's the culture, it's the politics more generally, not the weather of the day, but the climate of an era. And so the courts can do their part. They can be in dialogue with what's going on in national politics. But she has never been of the view that the court just renders its decision and the entire country simply falls in line. And so she was of the view that the politics was much more in flux at the time of Roe. I think she agrees with the view that the court's decision caused a backlash, and so she was concerned that the court had moved too quickly on the issue. And I think you see this show up in votes and behavior of the court on the issue of same-sex marriage. The court declined to decide the issue in 2013 in Hollingsworth against Perry, and appears poised to decide the issue now, in which the situation on the ground in the country is very different than it was.
So let's talk about her legacy. What does she have a theory of jurisprudence? Does she have a theory of judging? Let's do a little bit of a free-for-all here, and just kind of how do you see her legacy in terms of being a Supreme Court justice in particular? And Lisa, maybe we should start with you.
I have an interesting view on that because I sort of looked at it through a lens that gave me a very small focus because I wrote about her criminal procedure legacy, and she's not particularly well known in that area. And one of the reasons that I embarked on it is because I had been struck by a very recent dissent that she had written in the Connick case that was so impassioned. And I noticed something about that case that connected it, I thought, to an earlier decision, a decision in the Lilly Ledbetter case. These two very different areas of the law, and the same sense of injustice that she really expressed in both of those opinions. And I think both of them speak to her belief in equality, in fairness, and she understands it as fairness, in the way that Neil has already described. What she wanted was access to things. She wanted women to be getting into the workplace, to be getting into the educational institutions, to be having professional opportunities that they couldn't have because of formal obstacles that didn't make any sense. And she has the same cadence across substance, I think. And I noticed it in the criminal procedure decisions, where if you want to see her actually animated about an issue, it's about getting into court. And because she believes, I think, in fair play in a very deep sense and is committed to it, and also is a natural lawyer. She believes in process. She believes in things turning out right if you can just get past barriers. And a lot of her criminal procedure decisions speak to that, having the right lawyer, having access to discovery materials to which defendants are entitled, the power of juries to render certain kinds of decisions, the right to confront witnesses. Those are the sorts of things that get her attention, and they strike me as very consonant with her commitment to equality and fairness in other contexts.
Scott, other procedure contexts?
Yeah, I think, her procedure opinions, I don't want to bore you too much here, but her procedure opinions are really also about balancing fairness with cost and a sensitivity to the various law-speaking institutions that are involved in procedural rulemaking. So she tries, more than any other justice, she's really tried to leave space for the states to have a say in what goes on procedurally in federal court under the Erie Doctrine. I see people shuddering out there. I said Erie. In other procedure cases and jurisdictional cases, she is concerned about the cost, the reality of the cost of litigation today, and she has made some moves that have tended to try to bring sensitivity to those concerns about cost. I don't find her procedure opinions to be political in any way. Procedure itself is perhaps the most apolitical subject matter of the first-year curriculum, but she really does try to bring mindfulness and detail-oriented looks. She's the best. She's the techie on the court, and she has said that she would write every civil procedure.
So when you say techie, Scott, you don't mean right? You don't mean smartphones and computers. You mean technique, just to be right.
Yes.
Right, legal technique. Yeah, I mean, I clerked on the Court of Appeals and then for the Justice, and I always regretted not that I wasn't set up to do a district court clerkship, and then I spent a year with Justice Ginsburg, and I tell people that was my district court clerkship, just because of, I mean, she knew the record better than anyone else, and she knew the facts better than anyone else, and that was quite an education that I received. Constitutional law, I mean, there's a lot of it. I myself tend to focus on, in the area of constitutional law, equal protection, substantive due process, constitutional federalism, the relationships among them. I think she's most associated with equal protection and substantive due process doctrine. In those areas, I wouldn't describe her as possessing a theory of constitutional interpretation, just like I wouldn't. I mean, 7 of the justices self-consciously don't have a theory of constitutional interpretation, and then the 2 who do often don't follow it or they qualify it in various ways. So I think all the justices are methodologically pluralists. They look at the text, they look at original understandings of the text, they look at the purposes of a constitutional provision, they draw inferences from the constitutional structure, the institutions and arrangements that the Constitution creates. They care a lot about judicial precedent. They care a lot about historical practice. I think they all care a lot about consequences. Some are more likely than others to actually articulate their concerns. So I don't think she's distinctive in that regard. Instead of a theory of interpretation, I think of it more as a constitutional vision. I think she has a progressive constitutional vision. I think she looks at certain relatively open-ended and value-laden clauses in the Constitution, like the equal protection of the laws, life, liberty, or property without due process of law, and she identifies them with a certain set of values of inclusion. I mean, she calls it equal citizenship stature. She calls it equal dignity, full human stature. I think these all speak to her substantive constitutional vision. That in her view, the story of American constitutional development is a story of slowly, incrementally, but nonetheless, eventually, including within the Constitution's embrace, people and groups who traditionally didn't count for much in constituting the people for whom the Constitution purports to speak. And when I think you see this reflected in her opinions in the area of race, in the area of gender, in the area of disability, in the area of abortion rights and contraception rights. This idea of equal citizenship leads her to reject color blindness, gender blindness, formal equality understandings, and to embrace a more capacious, substantive understanding of equality. She's not just interested in whether the government has drawn a particular line, but what its purposes were, what the effects are, what the dominant social meaning of the government having acted or not acted the way it has. Those are all constitutionally relevant to her. And she ties this vision all the way back to the beginning. I think Thurgood Marshall tended to emphasize everything that the country accomplished despite what the framers and the founders did. And Justice Ginsburg, I think, gently in her own work has pushed back a little bit about that. She said that the framers and the founders rejected the patriarchal power of kings. They rejected the idea that political power can legitimately rest on birth status. And they slowly but surely included within the Constitution's embrace, she included white men without property. Right? That's where it began. Then we began a struggle that exists to this day to make citizens of former slaves full citizens in a real sense, in a sense that matters on the ground in terms of lived experience. She talks about disestablishing the separate spheres tradition, understanding that disabled Americans are disabled not so much because of whatever physical or emotional impediments they encounter, but because of a society that's structured in a way that denies them access. I think in all these areas you see different methodological interpretive techniques that are bound together, that are anchored by this progressive constitutional vision.
So again, from Dahlia Lithwick's chapter, she has two passages that I think they're very interesting, particularly when read together. In the first, she says that Justice Ginsburg spent a lifetime positioned midway between genteel intellectualism and daily acts of sexism. She has made a career of marrying the two, and she did so in a way that was far more effective, given the era, than acting out at the extremes. So that's one take on Justice Ginsburg from Dahlia Lithwick. And later she says that after Justice O'Connor retired, suddenly, in small and nearly imperceptible ways, Ginsburg began to voice her frustration, and she started to sound very different from the quiet, collegial Ginsburg we thought we knew. So I want to ask the panelists if you want to reflect upon what seemed to be, in several of the chapters, note a shift in her jurisprudence sometime around the time that Justice O'Connor left. What do you make of it?
So I think the first comment is very reflective of what Justice Ginsburg herself said in the video that she's an independent lady, so she balances those two identities. She is always poised. She's incredibly polite. She's calm and soft-spoken, but she's not a wilting wildflower. She is firm. She has a voice of reason and clear-sightedness, and that's always been the way that she has made her arguments and pursued her vision. What's changed since Justice O'Connor left is hard to say, but she has been much more in the limelight. She seems to have been much more outspoken with the media. She's issued more oral dissents from the bench. She has even done a little bit of lobbying to try to convince Congress to change the law in cases that she has been on the dissent, and successfully so. I don't mean lobbying formally, I mean just offering her support. But perhaps she feels like, and I'm just guessing here, and Neil may have other thoughts too, but perhaps she feels like she can do more than just write opinions, that she can continue to influence the law in ways that go beyond just her written opinions. And as for speaking out with the media, I think it's a way of bringing some humanity and humility to the court. It's like the opposite of the grand drapes that stand behind the justices in their courtroom. This is a person, and she, just like everyone on the court, has been influenced by her own experiences, and I think that's an important reminder for the American public.
I think it's important to remember as well that she's probably at a stage in her life where her own legacy is something that she thinks about, and to the extent that there are unfinished projects, the volume might go up a little bit when she talks about them. And I think she's also on a court that changed very, very rapidly after being stable for a very long time and made some marked shifts to the right at the same time. And so I think trying to account for the increased frustration that she expresses in some of her dissents, her increasing proclivity to read those dissents from the bench and express herself, her willingness to be a more public figure and make the same points, is, I think, partly about the moment in which she finds herself, both in terms of her personal life and the history of the court as an institution and where it has gone in the last few years.
I don't see a difference in the substance of her opinions in recent years. I do see two changes. One is that she's substantially more senior, and so she's writing either the majority opinion or more often the principal dissent in very big cases. After NFIB, for example, the healthcare case, you have a major Ginsburg opinion in the area of federalism. So I think that's one change. With more seniority comes a greater ability to write major opinions. And then the second change I see is that that she's angrier. As part of the DC Summer Institute, it's now in its third year, and the first 2 years she spent time with us. I do a public interview with her, and then she spends time with the students, so she's been very generous to Duke Law School, and she's going to do it again this summer. So if you're in the D.C. area, you're warmly invited to join us. But I asked her at one of these gatherings, how is the court changing? And she's saying the court is not changing, it changed. It changed when Justice Alito replaced Justice O'Connor. And so I think she perceives that a lot of what she has fought for, what she views as accomplishments of the court, is very much under attack, and she's less inclined to be collegial. Even though she's very collegial, she'll never write an opinion like, God bless him, Justice Scalia. She's not going to do that, right? But in terms of his capacity to be acerbic about his colleagues, but she is angrier, and I think she's more willing to express it, to sound the alarm bell than I think she was in the past, and certainly reasonable people can debate the propriety of the way she and the other justices conduct themselves.
Speaking of Justice Scalia, I just picked up this morning online the Times Top 100, and Justice Scalia has written the piece on Justice Ginsburg. And one of the things he says is, what only her colleagues know, he mentions that she writes well-crafted opinions, whether he agrees with him or not, with her or not. He closes, though, this very short piece by saying, what only her colleagues know is that her suggestions improve the opinions the rest of us write, and that she is a source of collegiality and good judgment in all our work. She's well known for how well she gets along with Justice Scalia outside the court. And I want to play one clip from an interview that Neil did. Not sure what year this was, Neil.
I think it was last summer.
Okay.
I think it was, yeah.
You just tell them, cut it out or cut it down, give somebody else a chance.
So he's talking about Justice Scalia, obviously.
He wrote the most number of opinions, and he asked the most questions at argument last term. And so I was saying, can he,
Don't you think he'd be responsive to that?
Well, Neil, he has been told that more than once, but he's irrepressible. There is a comic opera that was completed this year, and it's called Scalia Ginsburg. My feminist friends say, how could you allow it to be Scalia Ginsburg? G is first alphabetically. And I explained that in the court we do everything by seniority. So Scalia is a few justices ahead of Justice Ginsburg. Hence the opera is called Scalia Ginsburg. It opens with a kind of Handelian rage aria for Scalia, which goes like this. The justices are blind. How can they possibly spout this? The Constitution says absolutely nothing about this. And then my answering aria explains to Justice Scalia that he is searching for a bright line answer to a problem that has no easy solution. But the great thing about our Constitution is, like our society, it can evolve. And then we go on. Justice Scalia is imprisoned in a dark room for excessive dissentings. And I come to his rescue in a most dramatic way. I break through a glass ceiling to rescue him from his plight. And then the last duet is, we are different, we are one, explaining that we are different in the way we regard constitutional interpretation, but we are one in our reverence for the court we serve.
So I apologize that the video and the audio did not link up. What can we say about the relationship between Justice Ginsburg and anything more about Justice Scalia? Or I think, Lisa, you might have some insight about her relationship with Justice O'Connor.
I clerked for Justice O'Connor, and of course Justice Ginsburg was on the court at the same time, and it's hard even to describe the amount of reverence and affection that Justice O'Connor had for her, and how genuinely happy she was to have her arrive at the court after more than a decade of being the iconic woman on the bench on her own. And Justice Ginsburg herself felt quite lonely for a while after Justice O'Connor retired, and was delighted when Justices Sotomayor and Kagan joined her on the bench. And it's not because there's some tokenism at work there that's important to any of these people who are unique and serious and wouldn't value that in and of itself. It's because of that, what she was just saying actually about the aria reminded me of it, because having them together on the bench is that different and one concept as well. And one of the things that Justice O'Connor and Justice Ginsburg enjoyed the most about each other is that they were not, in many respects, similar. They didn't often agree on in certain areas of the law, and some they did. I think they would agree a great deal more today if they were both on the court today. I think they would agree almost all the time and be a formidable pair, and the court would be very, very different if Justice O'Connor were still there. But they didn't as much at the time, but the different ways in which they discussed the cases and presented themselves and the different worlds from which they came were in and of themselves a demonstration of the importance of having women on the court and the way that they were non-symbolic but substantive contributors to the court's work. And that certainly evolved because nobody confuses Justices Sotomayor and Kagan and Ginsburg. Although for a long time, even the most progressive and most seasoned of advocates would often refer to Justice Ginsburg as Justice O'Connor because under the pressure of the questioning, they would lapse into a shortcut in their response, and an unconscious bias would emerge, and they would assume the woman's voice must be Justice O'Connor. So they had a running joke about confusing the two of them and how implausible that would have been in any other setting. But it doesn't happen anymore. Nobody confuses the women on the court now.
Other comments about Justice Ginsburg's relationship with her colleagues?
I think that she values collegiality and has a thick skin, can duke it out in the footnotes of the Supreme Court Reporter, but is perfectly able to leave that at work and go enjoy the company of someone who makes her laugh, and I think Scalia did that.
I think when it comes to Justice Ginsburg, Justice Scalia, Justice Thomas, you could go down the line, their capacity to not take things personally when they each have so much power, when there's so much at stake, depending upon how they vote. I view Ginsburg not every court is like this, and not every court the justices have not always liked one another so much. When I remember there's a story that when Chief Justice Vinson suddenly died in the summer between the initial argument, the re-argument in Brown, Justice Frankfurter was recorded as saying that it was the first proof he had ever received of the existence of God. So there was no love lost there. Justice Ginsburg, mourned when her chief, she called him my chief, when Chief Justice Rehnquist passed. And I think the late Rehnquist court, the early Roberts court, I think there's a lot of, they have a capacity to forge not just relationships, but friendships across often steep ideological divides. And I view it, at least my best self views it as a model for the rest of us, because we have got to live together. This is a large, diverse nation in which people disagree intensely. And just like we as Duke come together, and we have friendships that don't track our politics. So I feel like if they could do it, then so can the rest of us. And I think the legal profession has an important role to play in providing that kind of leadership that the country sorely needs.
We have time for a few questions. Len.
I wonder if any of you, with your expertise on the justice, could comment on the views stated by a variety of liberals, Democrats, whatever you want to call it, that she should get off the court in time for President Obama to replace her. I think it was stated by your former colleague, Erwin Chemerinsky, among many others, and her disinclination to do that, despite the fact that, as a few of you have said, she seems to be a little angrier and more frustrated at the direction the court is going, and therefore might be as fearful of what might happen if she was replaced by a conservative as any of these people nudging her off the bench. I guess the question is anything you know about her personality and her worldview, is it consistent with her staying rather than going in a strategic way?
I guess I'll just read the tea leaves and say that she thinks she can still do great good on the court, and I think she really loves being on the court, and I certainly would never be one to tell someone to give up something that she loves.
Do you want to add anything, Neil? So Neil knows too much, so we can't have him answer that question. I do think it's also not from any knowledge that I have, but the same speculation that we all read, that she sees Justice O'Connor having stepped down arguably too early. and doesn't want herself to have made that mistake. It's an irreversible mistake. Other questions?
I read somewhere several years ago now where Justice Ginsburg was reported to have said that if a new nation were to begin to write their own constitution, they should look at the South African Constitution as opposed to the United States Constitution, and that drew a lot of comment from the press. I can see two sides of the argument, but I just would like your comments on that.
Yeah, I don't know anything about that.
I don't remember the particular instance that you're talking about, but it is it's a much more modern constitution. There are many more explicit rights provisions. The U.S. Constitution is dominated by negative rights as opposed to positive rights or entitlements, and I think the South African Constitution has more in the way of positive entitlements. It also, interestingly, no constitutional court in the world today has justices who serve for life. There are terms. I'm not sure if she had that in mind. The justices tend to like life tenure. I just don't know. But that's another striking feature of it is as well. There are some non-trivial ways in which modern constitutions around the world, as well as state constitutions in this country, which are much more easily amendable, are different from the U.S. Constitution.
Yeah, most folks would be shocked if Justice Ginsburg didn't come down, in favor of a constitutional right for gay marriage. I wonder if any of you have thoughts as to whether she or anyone else of the 9 arguably should have recused themselves. In her case, she's publicly officiated at gay weddings, and I just wonder in terms of how that looks from a political standpoint. Now you're going to decide the thing.
Well, if everybody had to recuse themselves, if they had a pre-existing view on gay marriage, it probably wouldn't leave anybody to decide this case. I don't know.
I think that's true of a lot of things.
Yeah.
Yeah. I mean, the question of law is whether there's an appearance of impropriety. I think what Kate is cautioning against is you'd be surprised at the frequency of the recusals. If having a view, having a relationship, giving a talk or a speech could lead to an appearance of impropriety. I mean, what you're implicitly saying is that if you officiate an opposite-sex wedding, that there's no appearance of impropriety there, but there is if you officiate a same-sex wedding, and I think that is already bleeding into contestable views about the merits. It's not evident to me, just from having heard what you said, that there's an appearance of impropriety by officiating at one as opposed to the other when both are pursuant to whatever.
She at both.
Right, she does both, and they're both pursuant to state law. So I'm not sure why that would lead to an appearance of impropriety.
David, is there anything you want to tell the group as a whole in terms of what comes next? Because
Let's thank the panel.
oh.